Good afternoon. It's nice to be back with you. The previous time that we met, we were dealing with the elements of crime. Elements of crime basically is an introduction to criminal law. And we're giving you a background of how criminal law evolved. And the general defenses in criminal law, participation in a crime. We also dealt with the punishment and principles of sentencing, just to give you an overview of what criminal law is all about. And this semester we shall go a little bit in more detail, because we have to deal with specific offenses. And as you may be aware from the elements of criminal law course, you will appreciate the fact that the Penal Code in Zambia is the major source of criminal law. So I implore each and every one of you to make sure or ensure that you have a copy of the Penal Code, Chapter 87 of the laws of Zambia. Such a copy can be obtained through the internet. You can download it. It's there on the internet. You can also perhaps buy yourself a copy from government printer, except I'm not sure how much it costs, but it's not something that you cannot afford to buy. Why? Because at the end of the day, when you do the final exam, all the statutes that you are going to deal with in this semester, as long as they are not marked, you'll be required to use them in the examination. And believe you me, if you don't have a copy of the statutes, such as the Penal Code, we'll also be able to deal with the Drug Enforcement Act, which they use. We'll deal with the Act used by the Anti-Corruption Commission, Immigration and Deportation Act, possibly the Farms Act, and indeed many other acts. We shall be able to refer to them. But above and overall, the major act that you really need to have a copy of is the Penal Code. Last semester, I think all of you apart from two did not make it. For you to pass criminal law, as I've already alluded to, you really need to have a copy of the Penal Code. Then at some point, of course not during this lecture, I'll be able to run you through on how you can tackle your assignment questions, on how you can tackle examination questions, final examination questions, so that at the end of the day, we do not record any failing, anyone among you failing. Because in my view, criminal law is one of the simplest courses that you can take, because after all, you are allowed a copy of the statute, so I don't see you failing. So, in as much as you'll be allowed a copy of the statutes, such as the Penal Code, I'll be able to guide and run you through on how you can use these statutes. It's not just a question of copy and paste, as it were. Now, in dealing with the Penal Code, we'll basically look at homicide. When we talk of homicide, this is the killing of a human being by a fellow human being, generally known as murder. It can either be murder, or the homicide can be manslaughter or infanticide. I will not go into details explaining what murder amounts to, what manslaughter amounts to, what infanticide amounts to, because there will be a time when we'll be able to tackle homicide cases, as it were. We'll also basically deal also with the sexual offenses. Now, when we talk of sexual offenses in the Penal Code, we're basically talking about rape. What amounts to rape? We'll be able to discuss that. Then, if the victim is below the age of 16, it will not be called rape, but it will be called defilement. So we'll be able to contrast defilement from rape. Then there's also indecent assault. We'll be able to distinguish indecent assault from rape and defilement. And then, of course, be able to understand what amount to indecent assault. Then the major offenses in Zambia, when we go by statistics from the Zambia Police Service, are offenses relating to property. And we'll deal with offenses against property in terms of theft, false pretenses, robbery, aggravated robbery, burglary and house breaking and theft. So burglary and house breaking are literally almost the same, but we'll be able to distinguish the difference between burglary and house breaking and theft. However, the elements are almost the same, and indeed, other offenses against property, we'll be able to look at that. Then you also deal with offenses against public order. So offenses against public order, typical examples is offenses against the state, offenses against public safety, offenses against public authority, then we'll be able to deal with offenses relating to religion, offenses relating to marriage and domestic obligations. Then also we should be able to deal with nuisances and offenses against health and convenience. We'll deal with offenses in relation to defamation. Defamation is twofold in law. There is civil defamation and criminal defamation. Civil defamation, you learn it under the law of tort. But also, defamation, as I've already said, it can either be civil in nature or criminal in nature. But we are not concerned with the civil aspect of it because we are dealing with criminal law. So basically, our interest in this regard will be that pertaining to criminal law. Then we'll deal with offenses in relation to criminal recklessness and negligence. Then also common and quite prevalent in Zambia are assaults. Assaults are in categories. We have common assault, we have assaults occasioning actual bodily harm, assault or battering of a child, assaults on persons, and so on and so forth. Then there are also offenses against liberty. These includes kidnapping, abduction, kidnapping or abducting with intent to confine a person, and so on and so forth. And for today, as I explained from the initial start, that we'll start with the offenses relating to property. Now, the Penal Code is divided in 2 chapters. Okay? So, offenses relating to property is found under chapter 24. Now, talking about chapters in the Penal Code, I think from the word go, it is important to outline that when you are quoting a section from any statutory provision, such as the Penal Code, you don't quote the chapter, no. You specifically go to the section that you intend to quote. Why do I say so? Of course, it was not your group, but the previous class, those who are dealing with the specific offences, the one which you are now will be dealing with yourselves. I was shocked to find that when they were actually quoting the provisions of the law, in this case, quoting the Penal Code, you'd find someone is quoting even the chapter where that particular section that he or she wants to quote. For example, if you want to make a reference to theft, and theft basically is contrary to Section 272 of the Penal Code, you don't need to say no, theft is contrary to Section 272 of the Penal Code, found in chapter 24, or found in chapter 20. It's found under chapter 26 of the Penal Code. I beg your pardon, I think I said it's found in chapter 24, it's chapter 26. You don't need to quote the chapter. You specifically confine yourself to the section and the appropriate legislation, in this case, chapter 87 of the laws of Zambia. So theft is contrary to section 272 of the Penal Code, chapter 87 of the laws of Zambia. Don't quote the chapter. I think we'll be able to discuss at length at some point on how you can actually quote sections in the Penal Code. So for today, we'll deal with offences relating to property. Now, for you to clearly understand what amounts to theft, when you go to section 272 of the Penal Code, it will not give you what amount. It will not, the particular section will not give you what amounts to theft. So for you to clearly understand what amounts to theft, there is need for you to go to section 265 of the Penal Code. So section 265 of the Penal Code clearly defines what amounts to theft. So we shall go through this section together and be able to understand it. So, as you can see, it is important for you to have a copy of the Penal Code, because if you don't have a copy of the Penal Code, then it will be very difficult for you to comprehend specific offences, because they're all, in the case of the majority of them are contained in the Penal Code, which, as I have already alluded to, you'll be allowed to use in the examination room, provided you have not written anything in your copy. So let's go step by step in understanding the definition of theft. So section 265, as I've already alluded to, give us a definition of theft. So section 265 subsection 1 reads, and I quote, "A person who fraudulently and without claim of right takes anything capable of being stolen or fraudulently converts to the use of any person other than the general or special owner thereof anything capable of being stolen is said to steal that thing." Now we need to understand the term fraudulently. What does fraudulently mean? In law, fraudulently basically means someone acting in a dishonest way, in a dishonest manner. That is fraudulently. Okay? So that's why the offense of theft is concerned with fraudulently taking of another person's property without claim of right. Without claim of right. Okay? Now, for example, what does the law under Section 265 emphasizes on fraudulent deed and without claim of right? Remember, from our discussion on elements of criminal law, we dealt with defenses under the Penal Code. And one of the defenses that we dealt with, if you recall very well, was that of mistake of fact. You all agree with me that certain items are so identical to each other. You may have a phone, Nokia, Samsung, whatever they make. That does not necessarily mean that you're the only one who has that kind of a phone. Suppose you have left your phone in the lecture theater. Then you have gone to check on a colleague in another lecture theater. And by the time you come back, you find that the lecture is over in your lecture room. And some students have gone, others are still in the lecture room. Then because you are in a hurry to leave, unknown to you, one of your colleagues has a similar phone, which is actually almost next to yours. Okay? Because remember when you went out the lecture theater, you could have left your phone in the lecture theater. Then you are in a hurry to catch a bus home because you want to reach home within the shortest possible time. Because you're in a hurry, you hurriedly pick another person's cell phone, which is so identical to yours, and you put it in your pocket. Now the question that may arise is that in so doing, are you acting in a dishonest manner, in a fraudulent manner, as you pick that cell phone which you thought was your cell phone because it's so similar to your phone? Of course not. You are not acting in this particular instance in a fraudulent manner or in a dishonest manner. But the scenario would be different if you yourself, you know that this phone that I'm about to pick is not mine. It belongs to one of my colleagues, except that the colleague is not around. And you pick that phone, hide it in your pocket, then you leave for home. By so doing, you are actually acting in a dishonest manner, because that is not your phone, and you know it from the bottom of your heart that is not your phone. And because it's not your phone, it means you have no claim of right over that phone. You cannot keep it for too long because it is not your phone. So basically, Section 265, Subsection 1 of the Penal Code is telling us that a person can only be deemed to have stolen if he or she acts in a fraudulent way, in a dishonest way. Fraudulent means in a dishonest way. And that person has no claim of right over that particular property in question. Okay? So now, let's look at the case of Muziamba versus the People. It is a 1975 Zambia Law Report at page 83. The brief facts of this case is that the accused person went to his field, or claims to have gone to his field to check on his field. And whilst he was in his field, according to him, according to the evidence that he gave during trial, he said he found a bull that had strayed into his maize field. That bull was not his, but he decided to keep it and kept quiet without informing the actual owner. Later on, the owner went and reported the matter to the police, who, through investigations, were able to trace the bull to him. So when he was asked, why are you keeping this bull? His initial reaction was that, no, it is my bull. Then upon further interrogation, he changed his story to say, no, I actually confined this bull because it had strayed into my maize field, and I wanted to keep it until such a time that I find the owner who should be able to compensate me. So you see, because of the two stories, at first he says, it is my bull. Later on he changes to say, no, it is strayed into my maize field and I kept it in order to find the owner and seek compensation. So the court invoked the provisions of Section 265 that he actually acted fraudulently, he was dishonest, and his intention was to deprive the owner of that bull, and he was convicted accordingly. Okay? So the term fraudulently in Section 265 is intended to add and does not add something to the words without claim of right. It means that the taking must be intentional. It must be intentional. Like I gave the example of you taking someone's cell phone, which you know is not yours. That is intentional. So the taking must be intentional and without claim of right. It means that the taking must be, it means that the property of another has been taken intentionally by the accused person. Okay? So property which is to be a subject of theft or stealing under the Penal Code is supposed to be a thing capable of being stolen. Okay? It must be something capable of being stolen. We will deal with that later on when we look at Section 264 of the Penal Code. It gives us things that can be deemed to be stolen, because it's not everything that can be stolen. Okay? So let's look quickly at Subsection 2 of Section 265 of the Penal Code. It states, and I quote, a person who takes or converts anything capable of being stolen is deemed to do fraudulently if he or she does so with any of the following intents. That is to say, under paragraph A of Section 265, subsection 2 of the Penal Code, a person will be deemed to have stolen under subsection A if his intention is permanently to deprive the general or special owner of the thing of it. Now, we need to understand the term general or special owner. Who is a general owner? who is a special owner. I will make you understand the two definitions by a simple example. With me here, I have a pen. Okay, this is my pen. I just bought it from a shop. It means I am the general owner of this pen. This pen, because I'm the general owner, I can lend it to someone who has no pen. Immediately I transfer ownership from me to that person. It means he becomes the special owner. Okay? So a special owner is one who has received authority from the general owner to use that particular property. Okay? So the general owner is the actual owner in simple terms. And the special owner perhaps is someone who the general owner has entrusted that property to him or her. I'm sure you are able to understand the two distinctions now. Okay? So an intent permanent to deprive the general or special owner of the thing of it. It means that, remember that gentleman who took someone's phone, which he knew was not his cell phone. And when he goes home, perhaps he gives it to his mother as a gift, or to his girlfriend as a gift. It means he has deprived that actual owner, the general owner, of that item. Okay. So the other aspect of theft is that an intent to use the thing as a pledge or security. An intent to use the thing as a pledge or security. What this basically means is that when you have gotten perhaps somebody's phone, okay, and the person who has stolen it perhaps does not even want to keep it for himself. He goes and gives it to another person whom perhaps he has a credit to say, okay, you can hold on this thing as security, when in fact it's not even his property. You give it back to me when I've actually given you back the debt. Okay. Then under paragraph paragraph C, an intent to part with it on a condition as to its return, which the person taking or converting it may be unable to. Okay. An intent to part with it. And I intend to part with it in such a manner that it cannot I beg your pardon, and I intend to part with it on a condition as to its return, which the person taking or converting it may be unable to perform. Okay, so that also amounts to theft. And I intend to deal with it under D, and I intend to deal with it in such a manner that it cannot be returned in the condition in which it was at the time of the taking or conversion. The best example I can give you is money. Let's look at X, who is a cashier at a bank. The cashier reports for work at bank X at 08 hours. Then suddenly, around 9 hours, his wife calls him on his mobile and tells him that, in fact, sorry, honey, I forgot to tell you that we have run out of meal, and the children will go hungry at lunchtime because there is no meal in the house. Unfortunately, that banker or that cashier has no money in his account, but he's dealing with money. Receiving deposits from customers who walk into the bank and paying out as demanded by them through withdrawal slips. So the bank at that particular day has given him a lot of money to transact with clients. So he says, this is 9 hours, and there's a friend of mine who's bringing me money at 14 hours because he owes me 200 kwacha. So since there's nothing at home, he gets 200 kwacha from the till with a view of returning it by 14-15 hours when the person who owes him money brings back that money. Now, when you look at money, each note has got a serial number. For argument's sake, he has taken 100 kwacha or 200 kwacha notes and calls for his wife to pass through the bank to collect the money so that she's able to buy mealie milk. For argument's sake, if the serial number for the first note is 001, then the other note is 002, and he gives to the wife. Are you saying when the friend comes who owes him money and gives him money, he gets out of that money 200 kwacha? Will it be the same denomination that he took with that authority from the bank and gave to his wife to buy mealie? Will it be the same notes that he now returns back to the bank? Because he may return back to the bank notes with serial number 025 and 027. And yet, what he got from the bank are notes bearing the serial number 001 and 002. Because they are not the actual notes that he has returned back to the bank which he got from the bank. It means he has stolen. In as much as, notwithstanding the fact that the amount is the same. But when he got the money in the first place, did he inform the bank? Is it the policy of the bank for a cashier to borrow money from the bank without the knowledge of the bank manager? Of course not. It means that cashier has acted dishonestly, fraudulently, and he has no claim of right over that money. Yes, he has brought back the money after a few hours, but it's not the actual notes that he has brought back, which he had initially taken from the bank. So this amounts to theft. So for you to understand the definition of theft, you need to clearly understand the contents of Section 265 of the Penal Code. It gives you what amounts to theft. Okay? So, Section 265 provides a science definition of the offense of theft, moving a little away from the common law offense of larceny. Larceny, by the way, is where there is a common law offense which our present theft originates from. Mind you, Zambia being a former British colony, much of our law is actually inherited from our colonial master, the British. Before this offense of theft was called theft, it used to be called larceny under the common law. Okay? But once there was legislation, it was changed from larceny into theft. But it keeps the law of theft in Zambia under the shadow of the common law. Okay, larceny. So it's just a reflection of the common law, this offense of theft. The section, that is Section 265, provides that a person who fraudulently is being dishonest, as I keep on emphasizing, takes or fraudulently conveys to the use of any other person anything capable of being stolen, is said to steal that thing. Is said to steal that thing. This definition is elaborated in the meaning of subsection of the same section, that is 265, which we have actually dealt with. Although, however, remember that, although Section 265 employs a simple concept of take in order to exclude the common law concept of asportation. However, the concept is retained by subsection 5. Subsection 5 of section 265. So let's read what subsection 5 of section 265 says. A person shall not be deemed to take a thing unless he moves the thing or causes it to move. So this brings about another major aspect of theft. For someone to be convicted of theft, there must be movement of the item stolen from point A to point B. Okay? Remember that person who took a cell phone from in the lecture theater. He found it on a desk when the owner was away, and put it into his pocket and moved from the lecture theater to his house, to his home, perhaps in Chalala, in Cheston, in Emersdale, wherever his residence is. So that amounts to theft. One, there's the element of dishonesty because he has taken that thing that doesn't belong to him and he has no claim of right. And there's that movement of the phone from the lecture theater up to his house in Charara, in Emersdale, in Woodlands, in Ililai, in Makeni, wherever he or she stays. Okay? Section 265 also requires that the thing must be taken fraudulently without claim of right. The inclusion of this phrase in section 265, which comes immediately after the word fraudulently, raises some problem of interpretation. Okay? That is according to Kurusika 206 at page 581. You need to have a copy of this book. It's a very good law textbook. I think I did mention it to you when we are doing specific offenses, that this is a very good latest textbook dealing with criminal law in Zambia. But in view of the, according to Kurusika, but in Kurusika 206, but in view of its definition in section 8, the phrase without claim of right is necessary because it is submitted the phrase claim of right introduces the two notions of honesty and without intention to defraud. And the negative of these two phrases goes to confirm that the taking is fraudulent, dishonesty, so to speak. The word fraudulently may be taken to mean that the taking must be intentional. Remember that person who took someone's cell phone in the lecture theater, which he knew was not his, that was intentional. Okay? And without mistake. Because the person knew that was not his cell phone, and yet he picked it and went away with it. And with knowledge that the thing being taken belongs to another person, the accused person must have that knowledge. Okay? It will be seen that fraudulently is one of the requirements of intent to constitute the offense. Okay? So the variety of intents which establishes that the accused person acted fraudulently are contained in subsection 2 of section 265, which we have already dealt with. Okay? It is also observed that the taking of conviction may have different legal consequences depending on the circumstances of the taking or conversion. For example, it is immaterial whether the thing converted is taken for the purpose of conversion or whether it is at the time of conversion in the possession of the person who converts it. Okay? There's one interesting case from Nigeria where the issue relating to fraudulent conversion was dealt with by the Federal Supreme Court of Nigeria. In the case of Nigeria, in the case of Ojiko, spelled as O-J-I-K-O, versus Inspector General of Police. In this particular case, the defendant received the sum of 300 naira. Naira is the denomination that is used in Nigeria, as we use the kwacha here. So he received, the defendant in this case, the accused person, received the sum of 300 naira from the complainant for the purchase of a piece of land in his own name, and then to transfer the land to the complainant. So he was almost more or less like an agent. Okay, the accused person did as agreed. The accused person did as agreed, but refused to transfer the land. Now the question that arose, did this amount to theft? Debate, did this amount to theft? I give you 2 minutes to think through. Someone is given money to say, look, in that area, I hear they are selling land. Here's the money. Go and buy that piece of land in your name. But at the end of the day, you are going to transfer it to me because I'm the one giving you this money. Now this money, this accused person goes as agreed, buys or purchases the piece of land using the money that has been given to him, but refuses to transfer the property to the person who gave him the money. Does this amount to theft? Does this amount to theft? The magistrate, in the case of Ojiko, convicted him of stealing the money. And on appeal to the High Court of the Western Region, this was dismissed. Why do you think the conviction was dismissed in the High Court? Why do you think? Because as a law student, you need to think through. Well, the defendant or appellant appealed to the Federal Supreme Court, contending that he could not be convicted for stealing by fraudulent conversion because he had used the money for the purpose for which it was given to him. He did not steal the money. He was told to buy land, and he bought land, except he refused to transfer ownership of the land to the person who gave him the money. But the lower court convicted him of stealing the 300 naira. So you can see how interesting it is in criminal law. The Federal Supreme Court agreed and stated that there was, the Supreme Court held that there was, on the facts of the case, no conviction of the sum. There was, on the facts of this case, no conversion of the sum of money because they were used for the purpose for which they were intended. Had the agreement been to purchase something capable of being stolen, and the appellant had refused to transfer that thing to the complainant after purchasing it, then he could have been properly convicted of stealing that thing, but not the money which had been properly employed to purchase that thing. In the circumstances, although we think that the appellant has acted dishonestly, we have no alternative but to allow the appeal. Okay? Then in this holding, the court raises a very interesting aspect of something capable of being stolen. So the question I now put to you, which I want you to think through: can someone steal a piece of land? In Zambia, we don't speak so much of land, but we speak so much of what is on the land. So I'll rephrase the question and say, can someone steal a house? Can someone steal a shop? Remember, one of the elements of theft is that the thing must be moved from point A to point B, like that example of the cell phone that I keep on referring to. Now, can you move a house in Emersdale to Chalala? Can a criminal go to Woodlands, find a very beautiful house in Ibex, steal it in the night, and go to hide it in Kabangwe or 10 miles? It's not possible, because that thing is incapable of being made to move. Okay? Now, there is also one aspect of theft which is in our statute book, but often is not often reported at the police station, dealt with by the police. We have an offense that amounts to theft known as theft by finding. What do you think amounts to theft by finding? If you find something, I found this bottle lying around, and of course belonging to another person, but there's no person in the vicinity, and I take it with me. Of course, it is someone's bottle, and I know this bottle belongs to somebody, but I take it with me because there's nobody in the vicinity. If I committed a criminal offense. So, theft by finding depends on the particular facts. This is amplified in subsection 4 of section 265, which is to the effect that when a thing converted has been lost and found by the person who converts it, the conversion is not deemed to be fraudulent if at the time of the conversion the owner is not known to the accused person. Okay? And 2, the accused person believed on reasonable grounds that the owner cannot be discovered. Now, in practice, if you find something of value and you have reasonable grounds to believe that the owner cannot be found, you need to go to the nearest police station and tell them, I have found this cell phone lying around at such and such a place. My name is so and so. I reside at such and such a place. I'm a student at Cavendish University, pursuing or reading law. Then the police will get your details. And under the Police Act, the police are empowered to give that item back to you, okay, so that you keep it. But you'll be told that in the event that the police receive a report of that missing item that you found on the way, you'll be summoned and you give it back to the owner. But in the event that no one comes forth to claim that item that you picked on the street, according to the Police Act, it means that item will be yours to keep. However, if you have not taken all these precautions that I've just alluded to, and you decide to keep it, when in fact, if you made inquiries, if you had reported to the police, the actual owner could have been found, then you will be charged with the offense of theft by finding. Okay. So from the foregoing and based on the provision of section 265, 5 elements of theft can be identified. So as a law, as a student of criminal law, you should be able to identify the elements of a specific offense that you are dealing with. Because it's not only theft, by the way, that you'll be dealing with. We'll be dealing with quite so many offenses. So in the exam, for example, you may be asked to identify what are the elements of theft, for example. And those can be obtained in section, or identified in section 265 of the Penal Code. But if you don't have a Penal Code, how are you going to be able to explain the elements of criminal law? By the way, law students in criminal law fail because when they ask a question, yes, we are discussing now, and some of you are very good at remembering what is being discussed. But when you actually come to write the exam, we shall not be interested in you remembering what you are discussing now. Of course, it's important that we discuss, but we want you to give us, for example, if a question was asked, what are the elements of criminal of theft? I will soon run you through the elements of theft as contained in section 265 of the Penal Code, which some of you who have got very good sharp minds will be able to remember even without making reference to any specific section in the Penal Code. And they'll come out clearly as they are contained in the Penal Code. Assuming that the question is out of 20 marks, you will get, because we are able to give us the correct answer, out of 20 marks, I should be able to give you even 8 or less than that. And yet you have given the correct answer. Why? Because in law, in criminal law, you need to tell us, you must have what is known as the authority for whatever answer you give. So the authority in this case can be by saying, according to section 265, subsection blah blah blah, the elements of theft are as follows. Okay, you can even spice it more by even perhaps quoting a cited case. So don't just answer from your head when you're dealing with questions in criminal law. These are some of the, if you do that, believe you me, you remain wondering to say, but I answered all the questions very well. Why is this Dr. Mbita giving me very few marks? It's because you have not been able to tell us the authority, the basis of your answer. Okay? So going by section 265 of the Penal Code, the theft has got 5 elements. 5 elements. Okay? One of which is there must be something capable of being stolen, which is property. We'll deal with what is capable of being stolen when we actually construe section 264 of the Penal Code. Okay? So for now, I will not tell you what amounts to things capable of being stolen. We'll deal with them later. Number 2, going by section 265, the thing must belong to another person. Okay? It means that property you have taken is not yours. It belongs to someone else. If it is yours, then you have not stolen. Although, in law, you can steal your own property. We'll deal with that later. And okay, let me give you an example of how you can steal your own property so that I don't leave you wondering. You have a motor vehicle and it's giving you a lot of problems, and you decide to take it to a garage so that a mechanic can work on your vehicle. When you take that vehicle to the garage, you'll be told to leave the car keys in the garage. But most vehicles don't only have one car key. It may have 2, even more car keys. Then the garage will work on your vehicle, and in fact, by the time you leave it, possibly they will examine it and tell you that, okay, for this problem, this is the problem. We work on it, no problem, and your bill is 5,000 patch, because the problem is so complex. Agreed, agreed. You go home, you realize that you don't even have anything on you, you don't even have anything in your account apart from the book balance, and you can only go to your to the university using your car, or if you are working, you have to use your vehicle on a daily basis. It is more convenient than jumping on public transport, especially in this era of COVID-19. It's not even safe to move on public transport because you don't know who sitting next to you, whether that person has COVID-19 or not. So it's a little bit more safe for you to move in your own vehicle. And you are told that within 2 days the vehicle will be ready. So you wait until such a time that the vehicle is ready, and you receive a call from the garage, come and pick your vehicle, it's ready. No, today I'm just trying to look around for the money. I'll come and pick it up tomorrow. By then I should have something on me to come and settle. Now, mind you have a spare key. So you go to the garage, you look around, you're all busy or there's nobody. Using your spare key, you drive away that vehicle. Have you stolen that vehicle, which is yours? The answer is yes. Because mind you, when you left it in the garage, you as the general owner, you transferred ownership in a way to the garage as the special owner. So you can only get it with the authority of the special owner in as much as it is yours. So you can see your own property. Okay? So the thing must belong to another person. In this case, that vehicle, in as much as it is yours, it's in your name. But at that particular time, it belongs to the garage as the special owner. Because you owe them money up until you pay for it, it's not your vehicle. So the other element of of theft, is that the accused person must take and move the thing. That vehicle was parked in the garage. The accused person has gone to that garage in as much as it is his, drives the vehicle from the garage to his home. So he has made it move where the special owner had parked it. So there must be movement of the property stolen from point A to point B. Okay? Then the fourth element is that the accused person must intend permanently to deprive another person of the thing. In this case, the vehicle. Because the garage is keeping that vehicle as security that you go and pay them the 5,000 that you owe them after the repair has been done. Then you decide to take it away from them. It means your intention is to deprive them of the 5,000 patch, or to deprive them of that property, which you have not cleared in terms of payment. Okay? Then the final and fifth element of theft is that the accused person must act fraudulently. Fraudulently, when you hear the word fraudulently, it means acting in a dishonest way. That is fraudulent, acting in a dishonest way. Okay? So fraudulently is the term used in section 265 instead of the term dishonestly. It's more or less like a legal term. Otherwise, there was nothing wrong if fraudulently was substituted with dishonestly. It is one and the same thing. However, for all purpose and intent, the Penal Code repeatedly uses the term fraudulently instead of dishonestly. Okay? So those are the 5 elements of theft. Okay? Now, we have actually talked about a lot about stealing, and that the thing that should be stolen must be capable of being stolen. I'll give an example of land, a house that cannot be stolen. No, because the house or land cannot be moved from point A to point B. So for you to further understand what amounts to theft, for you to further understand what amounts to theft, you need to go through Section 264 of the Penal Code. Okay? So Section 264 is intended to provide a definition of what property is. Section 264 of the Penal Code provides the definition of what property is. You need to understand what may be stolen, because it's not everything that can be stolen. Okay? So let's quickly go to Section 265 of the Penal Code and see what is capable of being stolen. So Section 264 of the Penal Code, subsection 1, says every inanimate thing, whatever which is the property of any person and which is movable is capable of being stolen. So inanimate thing means something which is not alive. A cell phone is not alive. Okay? So inanimate, don't be scared of the word inanimate. It's basically something that is not alive. This bottle is not alive. Okay? I don't know in science if it can be described as a living thing, I don't know. But in law, this may be termed as something which is inanimate. Okay? Which is the property of any person and which is movable. I'm just lifting this bottle at will. It means it's movable. Okay? And it may not necessarily be my property. It may belong to someone else. So subsection 2 of Section 264, every inanimate thing which is the property of any person and which is capable of being made movable is capable of being stolen as soon as it becomes movable, although it is made movable in order to steal it. Okay? That person who went to the garage with a spare key, the vehicle stationed in the garage, but using a spare key, he was able to move it from the garage to his home in Emersdale, to his home at 10 miles, or wherever he stays. Subsection 3. Every tame animal, whether tame by nature or wild by nature, and tamed, which is the property of any person, is capable of being stolen. So every tame animal, a cat, a dog, to mention but a few, can be capable of being stolen. Okay? Subsection 4. Animals wild by nature of a kind which is not ordinarily found in a condition of natural liberty in Zambia, which are the property of any person and which are usually kept in a state of confinement, are capable of being stolen, whether they're actually in confinement or have escaped from confinement. Okay? In Lusaka, I can think of one ranch, privately owned, at Dilai. not far from the police college. There's Lilai Lodge. And if you have a bit of some money, you go there, you're going to find animals such as zebras, giraffes, duikers, to mention but a few. Those are animals wild by nature, but they're actually tamed there. That's not the only place. There are other ranches elsewhere in Zambia, even in Lusaka. So, suppose an animal escaped from that ranch. Does it mean that anybody can just slaughter it and kill it? No. Because if someone did that, then according to subsection 4 of Section 264 of the Penal Code, that person will be deemed to have stolen that thing. Okay? Because that animal is capable of being stolen. Subsection 5, animals wild by nature of a kind which is ordinarily found in a condition of natural liberty in Zambia, which are the property of any person, are capable of being stolen while they are in confinement and where they are being actually pursued after escaping from confinement, but not at any other time. So this subsection 5 is a little bit similar to subsection 4. An animal wild by nature is deemed to be in a state of confinement so long as it is in a den, cage, style, tank, or other small enclosure, or is otherwise so placed that it cannot escape, and that its owner can take possession of it at pleasure. So you see, the law is so much talking about animals. It means the law really want to protect the animals, as it were. Okay? So all animals under subsection 7 in the enjoyment of their natural liberty are not capable of being stolen, but their dead bodies are capable of being stolen. Now, this what this section literally means is that if, for example, an accused person a poacher goes to South Luangwa National Park. I'll refer to South Luangwa National Park because I've been there before. It's one of the best parks that you can think of visiting in Zambia. So nice. You find a lot of wild animals, lions, leopards, elephants, you name them. Now the law here is a little bit not clearly defined, because they're saying wild animals in the enjoyment of their natural liberty are not capable of being stolen. I think you may recall not long ago, I think last year, where there was a plane that flew in one of our game reserves. I think that was in Western Province from South Africa, which was intercepted by ZAF, and they were found loading wild animals into the plane with a view of flying those kind of species out of Zambia to South Africa. Now, when you look at this particular section, which means those people cannot be charged under the Penal Code in terms of theft of those animals, because the law here seems to be contradicting itself. In fact, those were charged, I think, under the Zawa Act, okay, the Wildlife Act, because if they were to be charged for theft, I don't think they were going to be convicted, because wild animals, according to subsection 7, wild animals in the enjoyment of their natural liberty are not capable of being stolen, but their dead bodies are capable of being stolen. It means the legislature at that time only thought of poachers, because poachers, when they go into these parks, they don't go there to steal live animals. They go there with guns to kill these animals, skin them, then sell the carcass. Okay, I think this is why the legislature at this particular time did not focus into illegal dealings such as animals being stolen from national parks, being taken outside the country, or being taken into a private ranch, and so on and so forth. Okay, so it's a little bit not clear in terms of theft, because it means I can walk into a park, steal a buffalo, load it into my truck. As long as it's alive, it means I've not stolen it. Doesn't really make much sense. But of course, that does not mean that I cannot be charged for any criminal offense. I'll be charged under the Wildlife Act because there's a provision for that. But for theft, I will escape punishment, because I'll tell them, no, this animal was alive when they found it with me. I did not kill it. And subsection 7 says wild animals in the enjoyment of their confinement are not capable of being stolen. Okay? In case they find me, I've loaded it on a truck within the national park. There's no theft according to this subsection. So subsection 8, everything produced by or forming part of the body of an animal capable of being stolen. Everything produced by or forming part of the body of an animal capable of being stolen is capable of being stolen. I think here you can, like most poachers, they will go into a national park for ivory, for rhino horns, and so on. That's why right up now in Zambia, the only rhinos we have are found in the game park in Livingstone. 2 of which were actually, in fact, we got a female and a male from South Africa, and then they started reproducing little ones. Unfortunately, 2 of the little ones, I think some 6 months ago, were bashed by a truck coming from Namibia. In fact, a Zambian truck coming from Namibia. Okay. Now, if someone removes, let's say a horn, then because it's a part of the body of that animal, then that would amount to theft. But of course, the punishment would be so minimal unless that person is convicted under the Wildlife Act, like being in possession of government trophy and other related offences. So you can see from section 264, it clearly elaborates things capable of being stolen. Okay. So, section 264 is intended to provide a definition of what property is. It only shows that every inanimate thing, something which is not alive, inanimate thing, whatever, which is the property of any person and which is movable, is capable of being stolen. There is reference to tame animals and animals wild by nature, which are deemed to fit the description of property before and belongs to any person. These are things capable of being stolen. It is clear that the definition of property under section 264 is inadequate. Definitely it is inadequate. I agree with Kurusika 206. And needs to be reconsidered to avoid giving the court's wide discretion in determining what is a thing capable of being stolen as defined under the provisions of section 264 that I just ran you through. So property may include the following, going by the provisions of section 264 of the Penal Code. It may include money. It may include all real property. When you talk of real property, we're talking of land, houses. That is real property. Okay? And things attached to the land. For example, houses, things grown wild on land, and wild animals. These are mentioned in section 264. Then property also includes all personal property, for instance, all property that is not real property. Examples are things in action, non-physical property, one's rights which can be enforced by a legal action, for example, a debt. A bank owns the money deposited in the accounts of customers, but it owes a debt to such an account holder. The date is a thing in action and can be stolen. A check is a piece of paper with a special, a check, I beg your pardon. A check is a piece of paper with special qualities, and also a check is a thing in action and it's capable of being stolen. Other things in action include a copyright, a trademark, and shares in public company. It seems that a patent is not a thing in action. It is an intangible thing. Trade secrets or information is not protected by law as intangible property, as a copyright is protected. The point is illustrated by the case of Oxford versus Morse, spelled as M-O-S-S. This is a 1978 case, in brackets, 78, we put it in brackets, 68 Court of Appeal, ARA, at page 160, at page 183. In this case, a university student took an examination paper before the examination and copied it before returning the paper to its original location. It was held that he had not committed theft. The law considered the university not to have been deprived of any property. Most would have been convicted if he had not returned the paper to its original location. It is arguable whether the result would be reached in respect of a student photocopying some pages of a book. Okay? Then Kulisika argues that a human body, as far as the law of property is concerned, is not property. Okay? Now, let me pose a question. Kulisika raises a very interesting aspect. Suppose you have lost a beloved one, and we take our beloved ones. Here in Lusaka, you can take the beloved one to the university teaching hospital morgue, or to a private funeral parlor, such as St. Anne's. Then a date is set for burial, and as relatives, you go to the funeral parlor, or to yet morgue, only to find that the body is missing because it has been taken by another person. Has that person stolen that body? So that person may not be charged for theft. In the last examinations for your colleagues who are dealing with specific offences, I did raise a question where I gave a scenario of a funeral taking place at Memorial Park, where X goes to attend. This burial was for a prominent businessman who was put in a casket worth, for argument's sake, 45,000. Expensive suit, expensive blanket, expensive wristwatch buried with him. And during body viewing, X was able to see all these things. When this deceased person was buried, of course I'm not saying it happened, it's just a fictitious scenario. When this person is buried, X waits for the night to fall. He goes alone to Memorial Park and digs up the casket. He wraps the body of the deceased in a blanket and he buries it, but picks up the casket, cleans it up, and sells it. If he was to be apprehended, has X committed a criminal offense? What would be your answer? Because we have so far discussed what amounts to elements of crime, elements of theft. We have also discussed what amounts to things capable of being stolen. This scenario is more or less like, I want you to imagine at your house, you have dug a rubbish pit, okay, popularly known as Umuganda, behind your house, where you can throw a bottle, where you can throw garbage from the house, where you can throw anything that you consider not to be of value to you. You can even throw their old clothes. Now suppose somebody comes to that pit, rubbish pit, and picks up old clothes that you have thrown, and you see him picking up those things and walking away. Are you going to shout at him to say, "You, why have you taken those things from the rubbish pit? You have stolen," and report him or her to the police? Obviously not. Because immediately you throw something in a pit, in a rubbish pit, it ceases to be yours and it ceases to have value. Because for something to be capable of being stolen, it must belong to another person and it must have value. The value doesn't matter, it can even be one ongwe, that is the value. Someone can be convicted for stealing property worthy one ongwe, because that is value. But immediately you throw away something which ordinarily had value, it means immediately it's in that rubbish pit, it has no value, and whoever picks it up, immediately he or she picks it up, it becomes his or her, and it will have value because it now belongs to that particular person. He'll be able to give the value for that item if that item is stolen from him or her or someone else. So in the case of unfortunately, I know it is sad, it's Zambian, we wouldn't encourage people to go to cemeteries and unearth our loved ones and get expensive coffins. No wonder you see people, when they're burying their beloved ones in expensive coffins, they'll go there with the cement. Immediately the casket is lowered down. First there'll be cement with crushed stones mixed so that no one should be able to dig up that coffin at the end of the day. So in this question that I asked, others were saying no, there's theft, others they were saying there's no theft, and so on. It goes to the scenario that I've given you of you throwing something on a rubbish pit. Unfortunately, once we bury our beloved ones in those expensive coffins, immediately we put them in those graves. Those graves are more or less like rubbish pits. It means we have thrown the body, including the coffin, the clothes, whatever, no matter how expensive they are, immediately they touch the ground, they are of no value. Even if someone went there to unearth, you can never, he or she cannot be convicted of theft, no. But of course that person may be charged for trespass on the burial grounds, because no one has authorized him to go there and dig up that coffin. Of late, if you follow the print media or electronic media, where is it Chingorere Cemetery here in Matero, where some unscrupulous people, for whatever reasons, I don't know, they were busy digging up corpses of still babies, those babies that are born dead. They would go there and dig up the bodies. Fortunately enough, they were cornered and apprehended by the Lusaka City Council police, but they could not be charged, or cannot be charged for theft other than trespass on the burial grounds. So you can see when it comes to dead relatives being buried on the ground, there is no moral fiber on the part of criminal law in giving, deeming our dead brothers and sisters' coffins to be of value. No, unfortunately, there is no moral fiber. But the law is dynamic. It keeps on changing over the years, over a period of time. There's no harm in the legislature revisiting the law and giving value to coffins so that people who go to steal these coffins can be dealt with severely by the law. But as the law stands, there's no theft if someone goes and steals articles buried with our beloved ones. Now, we need, as a criminal law student, you need to understand that we dealt with the issue of mens rea, actus rea. Mens rea, just as a reminder, is the mental element of an accused person before he or she commits a crime. Because if I want to steal this bottle, I will not just straight away steal it. I'll start thinking of, I'll start admiring it within my heart. And no one will know that I'm admiring that bottle. It means I'm developing a criminal intent in my mind to steal. That is mens rea. Actus rea is when I move the item from point A to point B. It means I've now actualized my intention to steal. There's that movement from point A to point B. So you need to understand, as a student of criminal law, what is the mens rea of theft? What is the actus rea of theft? Each and every offense that we'll be dealing with, you need to understand the mens rea and the actus rea. So what do you think is the mens rea in theft? What do you think is the mens rea in theft? What do you think is the mens rea in theft? What do you think is the mens rea of theft? So, according to Kurusika, because, by the way, the mens rea, you cannot find them written in the Penal Code to say this is the mens rea of theft, this is the mens rea of murder. You must be able to pick it out yourself as a law student, as a student of criminal law. So the elements, how you can pick it out is by you understanding the ingredients of a specific offense. Then to be very easy for you to understand the mens rea and actus rea of a specific offense. As simple as that. So according to Kurusika 2006 at page 586, the elements of the mens rea of theft comprise A, fraudulent intent, dishonesty. Fraudulent, each time you hear of the word fraudulent, remember it's about dishonesty. So fraudulent intent, dishonestly under English criminal law. So there must be fraudulent intent, dishonesty in short. Then the intention, I repeat, the intention of permanent deprivation of the property, of that particular property from the owner, depriving the owner of that property. like that gentleman who picked a cell from the lecture room and took it home in Makeni or Chalala. It means his intention was to permanently deprive the actual owner of that particular phone. Okay? So mens rea, as I've already alluded to, normally refers to a state of mind in relation to consequences or circumstances surrounding an accused person's action. In determining whether the accused acted fraudulently, the law inquires into whether or not the accused person intended or foresaw or knew of something occurring or taking place. Very, very important. So the Penal Code provides some definition of the term fraudulently, but the definition does not tell us how the test should be applied to determine whether or not the accused person intended permanently to deprive any person of his or her property. It means that the determination of fraudulently must be put off until and unless the issue relating to intention of permanent deprivation is resolved. The definition of fraudulently is contained in subsection 2 of section 265. This does not need further elaboration because we've already discussed in detail. However, in considering whether or not there existed one of the fraudulent intents specified in subsection 2 of section 265, the simplest test may be to raise the question as to the intention of the accused person at the time of taking or conversion. To establish this is more difficult than proving the dishonesty of the accused person. Okay? So we have dealt with what amounts to things capable of being stolen under subsection 265. Then we have grasped the definition of theft. Then theft itself is contrary to section 272 of the Penal Code. So let's look at section 272 of the Penal Code, and you can only look at the section if you have a copy of the Penal Code. If you don't have, what are you going to look at? And when you look at the section itself, which amounts to theft, it will not give you a definition of theft. It will not give you what are things capable of being stolen unless you look at sections 264 and section 265 of the Penal Code. But theft is contrary to section 272, which reads, and I quote, any person who steals anything capable of being stolen. We have already dealt with things capable of being stolen when we looked at sections 264 and 265. He is guilty of the felon termed theft, and unless, owing to the circumstances of the theft or the nature of the thing stolen, some other punishment is provided, is liable to imprisonment for 5 years. So that is the maximum punishment one can get for theft. And this does not necessarily mean that the person who commits theft to be convicted to 5 years. It may be less. No? The person may be given an absolute discharge. The person may be given a conditional discharge, and so on and so forth. It's entirely up to the discretion of the court. So basically, you need to understand what amounts to theft. So the next time we meet, because we now understand what the things of capable of being stolen are. We understand the definition of theft. So we now look at silent elements of theft in the Penal Code. Of course, we cannot look at each and every offense, but we look at some, such as the theft by servant, stock theft, theft of motor vehicle, and so on and so forth. I appreciate that indeed from today's discussion I've given you an insight of what theft is all about. Things capable of being stolen, the definition of theft itself. So it will now be very easy for you and me to discuss specific offenses relating to theft, because at least we know the genesis of theft. So it will be very, very easy for us to discuss in much detail. However, please have a copy of the Penal Code. Have textbooks dealing with criminal law. One that I can recommend to you is that of text, cases and materials on criminal law in Zambia, written by Simon E. Klusika. Professor Klusika, I think, is one of the lecturers, part-time lecturers at Kabidesh, but full-time at Open University. And of course, there are many other textbooks written by English authors, which you can easily access from the Invest Library. Because at some point we'll give you some assignment. When we give you the assignment, you don't just refer to the Penal Code. You refer to the Penal Code, you also refer to textbook writers, authors. What have they said in relation to the question? Okay? But for the exam, you cannot come with a textbook, you can't come with a module, you have to come with a fresh copy of a piece of legislation that you are going to deal with. Specific offenses, you need to know the ingredients of each and every specific offense. Next time when we meet, when we start specifically looking at each specific offense, I'll run you through and make you understand how you are able to understand the ingredients of particular offenses. Ladies and gentlemen, because we are in this unfortunate era of COVID-19, we will not be meeting in person for now. So what I would suggest, of course with your approval, if you all agree as a class, is that I'll be recording the lectures for you, then post them, send them to you through your WhatsApp and the Planet, so that you listen to them, the lecture. Because the lecture is recorded, you should, when you are listening to the lecture, have a book with you, a notebook. Where you don't understand, you now post the question on Planet. Then I'll be able to answer you immediately on Planet. I'd have loved that we use Google Meet, but you know, the time when I'm supposed to be with you on Google Meet is actually the time that I'm supposed to be in my office. And believe you me, my office is a very busy office. What would be happening is that I could be on Google Meet live with you, then someone knocks. It means I have to interrupt the lecture. Then perhaps, and you know, you can't just chase someone from the office. Perhaps that person, I may be with him or her for 30 minutes. Would you be, and I don't think you'll be able to wait for me that long. So the best for now that we can do is that I'll be recording the lectures and post them to you. Then ask questions on Planet that you do not understand emanating from the lecture. Then I'll also be trying to send you notes that you can read on your own from what we have discussed. Okay? But when there's time and I'm not busy, perhaps I can, once in a while, I could take a day off from work. I should be able to meet you on Google Meet live so that you're able to ask questions there and then. For today, I hope you enjoyed the discussion, and believe you me, specific offences, as long as you're able to have a copy of the Penal Code, 1 or 2 textbooks on criminal law, I don't think we are going to have any problem. Of course, supplemented by the modules. Thank you so much. Books that are good.